Let's bring you more now on that breaking news story, which is that the government plans to give new judges powers to force criminals back into court to hear their sentencing. Joining me now is the criminal defence lawyer, Joseph Kotrie-Monson. Joseph, good to see you this afternoon. I mean, your firm specialises in murder cases and you represent people facing such charges. Is there really an objection to why this shouldn't be the case?
Interesting, Ian. I think, first of all, the sentiment in the context of the Letby case, the Thomas Cashman case, celebrated or notorious in a similar sense, Ian, going back as far as Dale Cregan, the double police killer not far from me in Manchester, who perhaps set the trend, the fashion among defendants who realised that the emperor was wearing no clothes and, in fact, they can't be forced easily to attend. Sentencing is important, just as the proceedings are important. Justice, Ian, should be seen to be done. That's the phrase that we're taught in law school. That's the phrase everybody knows. And for families of victims who are, as in the Letby case, so often deprived of answers, why this indiscriminate choosing of my child, for example, one of many, many questions from a defendant who denies it. Well, this is one last chance at that almost untouchable feeling that we can describe but is hard to attain of closure, and they shouldn't be deprived of it in most people's view. And Parliament, having first of all said, well, 2 years already exists, which it didn't, that was a misrepresentation of the Contempt of Court Act, that they're now actually enforcing the attendance, which I think will probably in reality just mean that everybody attends.
This will require, Joseph, a change in the law, probably via the Contempt of Court Act, from what you're saying there.
Yeah, well, it would be a new act of Parliament. It'll be rushed through by popular consensus, because we know already, don't we, that Keir Starmer has said this is something that should have been sorted out. Should have been sorted out already. But Ian, the law is one thing, and I have to say enforceability is another. I think in reality, in most cases, what we will see is when defendants know that they'll be dragged into court, they'll just go willingly. One can't imagine most defendants, when provided with that sense of resistance, doing anything except just giving up and attending. But for the type of defendant, for example, perhaps like Cashman, perhaps like the more deluded, angry, furious at the conviction types who won't accept what has happened, well, what kind of compliance will courts get? Bearing in mind, once somebody is getting a whole life term or a very long sentence, an extra couple of years on the sentence, for example, or a further prison sentence won't motivate them to comply. And families do not want an unengaged or disruptive defendant who turns up and says la, 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 or starts screaming and shouting. That is not the dignified process. And enforcing that is altogether more difficult. What will we see next? Gagging in certain cases. That would be an altogether more grotesque step, I think, and dignity is what's required here. I think in various cases we will see, generally speaking, an improvement in the numbers of people who actually attend, especially in these long sentences cases, but there is a potential for this chaos, altogether ungratifying, and Ian, not the kind of dignity that families hope for or deserve.
Absolutely. Put this into an international context for me, if you would, please, Joseph. What's the law in other countries?
Well, in the US, where we have probably the most popular knowledge, don't we, of these types of cases, we have defendants who are in court throughout, shackled in most cases throughout. They have to listen, and and those hearings are broadcast. Those powers have been in place in many jurisdictions for a long time. And of course, we also see, don't we, in those viral videos on YouTube and what have you, that there are circumstances where defendants behave particularly badly and they fly around the internet like wildfire, don't they? I don't think there's any easy solution, but defendants having the choice of how they engage with proceedings, simply because they've got away with simply because it's come on top for them and it's no longer going their way. I have to say, I'm a defence lawyer, but it smacks slightly of the entitlement of the generation.
Joseph, you specialise, as I said in the introduction, in murder cases, but also in cases of infanticide. I mean, these must be gruelling cases to be involved with. Yeah,
very much so. And I think all court users, from the jury, the ushers, the security staff, the judge, prosecution, and the defence, who have to provide their very best to make sure that the trial is fair and people know that the right people go to prison. All of those groups of people in a case like this, which the details of which live with you for a long time, they all deserve credit and gratitude. Not just the police, for example, who catch the killer, but everybody who makes sure that the process by which this whole thing occurred is one that we can rely on and be proud that actually this is not just trial by media. We don't like it. We hear the allegations and therefore, well, who cares if they have a defence? This is properly done. And the people who are innocent, as we must not, from our spots watching our television sets, decide in advance, well, that we can decide. But the people who are, as to who's innocent and who's guilty, but the people who are innocent do go free. That's the kind of justice system that can be seen to be done and should.
Joseph, we have to leave it there, I'm afraid. Really appreciate you joining me this afternoon. Thank you.